records of proceedings held on November 22nd for State of Indiana, Nick McClelland, for defendant Brad Rossi, Andrew Baldwin. Here, Judge Gould has been appointed as a special judge, with Jody as reporter. Jody is the one that there's a lot of people who has been sending in money for exhibits, who are still waiting for it, who have sent. She is the one who said to Criminality that $5,000 and change for the trial transcript, which we fundraised parts of. Well, we did fundraise more than $5,000. But another clerk of court decided to, no, let's publish this with no cost. So, which begs the question, where did Jody, where did all that money go that people sent in for evidence? They sent in cash and thumb drives for specific evidence. Where did that money go, Jody? Did you do a Becky Boo and pocket it? I don't know. Begs the question. Andy called her and she told me it's been returned. Okay, do a FOIA on the actual returns. Do a FOIA on how did you return it. Everybody who has sought the transcripts and the evidence should be recorded. Though that information should be able to be FOIA'd. Appeals are made for walking. Do you think overturning on appeal is possible? Yeah, it should be. With all the shenanigans that went on in this case. But if this is the trial transcript, which we already know in volume 2, things are missing. And the appellate attorneys who are assigned to this case, they are not commenting at all. Yes, the process of appeal is ongoing, as far as I know. I've heard good things about his appellate attorneys, but apparently they do not comment. And that's a choice. All right, let's continue here. Proceedings. The court, we are on the record. Good morning, Attorney McClelland. Good morning, Judge. The court, good morning, ladies and gentlemen. Welcome to Carroll Circuit Court. As Officer Bode has indicated, my name is Frank Gall. I am a judge in Allen Superior Court in our criminal division up in Fort Wayne, Indiana. I'm serving as special judge in the state of Indiana versus Richard Allen. I was appointed on November 3rd of this year by the Indiana Supreme Court by Chief Justice Rush. I will show that the defendant is here in person with his attorney, Mr. Bradley Rossi and Mr. Alec Baldwin. The state is here by the elected prosecutor, Mr. Nicholas McClelland. We are here today on the state's verified request to prohibit public access to a court record that was filed with the court October 28th of 2022. Before we begin, I would just like to inform those of you present here in the courtroom of the courthouse management and decorum order that was entered for this hearing on November 22nd, that I entered with the court on November 18th of 2022. The attorneys received this order, so they know what to expect. And you already, ladies and gentlemen in the gallery, experienced some of the directives. Only one entrance to the building was open. You were searched. Your bags were searched. If you have your cell phone here in the courtroom, again, please ensure that the cell phone is off and no other electronics are permitted in the courtroom. I will tell you, consistent with my practice, In Allen Superior Court, if your phone goes off, I will have it confiscated and it will be destroyed. Folks, I've been talking to Indiana-based attorneys and attorneys from other states. That practice has no legal basis. Confiscating, yes. Temporary. The law in Indiana only allows electronic devices to be temporarily confiscated and then return at the end of the day. Judge Gull actually does this. There's been articles about her confiscating phones and tablets and then keeping it for destruction and then destroyed it. And that goes for reporters as well. That is an illegal practice. But why does she do it? Because every time it has been brought up, nobody does anything in the PS Court or Supreme Court. She is allowed to do this, and she will keep doing it because nobody stops her. So what to do if the entirety of the Indiana justice system, despite knowing it is illegal, don't do jack shit about it? What to do? Except talk about it. Except talk about it. Bring it up. Do not stay silent. Do not stay silent. All right, let's continue. Oh, so I see here we are now over 100 people here. And have you all pressed the thumbs up, folks? Have you? If you haven't, please do so. You all know the YouTube things. The more thumbs up, the more comments, the more active chat, the more it gets promoted outwards. So half of you haven't pressed the thumbs up. Folks, come on. It really isn't that hard. If I can get Megan Fox here to tell you, or you will do it. Yes, I'm threatening you with Megan Fox. Oh. All right, let's continue. She continues with, ladies and gentlemen, please remain seated throughout the proceedings as we go through this hearing this morning. If you must leave, please do so quietly and please do so with the least amount of disruption possible. Once the hearing is concluded, I would ask that you remain seated until the parties and the court has left the courtroom and courtroom security indicates that you may leave. Mr. McClelland, on October 28th of this year, the Carroll Circuit Judge granted your verified request to prohibit public access to a court recorder and order the charging information and the probable cause and other court documents sealed and deemed to be a confidential court recording pending public hearing. That order is scheduled November 22nd at 9 a.m. to be that public hearing. Yeah. I mean, throughout the years, and especially after Rick Allen was arrested, there's been press conferences, there's been articles, everything. But the moment, this is not unusual. Oh, at the beginning of everything, let's have the prosecution story out there, and then boom, seal the records, preferably put a gag order so that the defense can't reply in public. It's not unusual. It is to ensure a fair trial. Fucktards, the only person with the right to a fair trial is the defendant. What the prosecution has is an obligation to conduct a fair trial. They have zero rights. They have only obligations. But if prosecutions around the countries whine hard enough and long enough, there will be a statute. Yeah, they also have a right to a fair trial. No, this pisses me off to no extent. No, they have an obligation to conduct a fair trial. That's it. That order is blah, blah, blah. Under the Indiana Rules of Court, the rules on access to court records were effective January 1st of this year. The burden is on the state of Indiana to demonstrate by clear and convincing evidence that the requirements of Rule 6, Paragraph A, have been satisfied. Since we are proceeding under the Indiana Rules of Court, rules of access to court records are not applicable. The Access to Public Records Act under the Indiana Code requires the state to proceed under the rules of trial rules. So we will be proceeding under that. Therefore, no public testimony or comment is necessary, as that is only required under the Access to Public Records Statutes Title 5. So, gentlemen, are you ready to proceed? Brad Rossi? Yes, ma'am. McClellan? Yes. Court? All right, Mr. McClellan, you may proceed. Thank you, Judge. As the court mentioned, the state did file a verified request to keep the records confidential, and specifically the probable cause affidavit and the charging information. The state's proceeding under Rule 6, and what Rule 6 says, Judge, is in extraordinary circumstances, if the state showed that the public interest will be substantially served by prohibiting access, or the access will create a substantial risk of substantial harm to the state or other persons or the general public, or that a substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting access, the court can restrict access to those records. As the court said, the burden is on the state. I must show by clear and convincing evidence that at least one of those requirements are met. Doesn't have to be all of them, Judge, just one. And then if the court does decide to keep the probable cause and charging information confidential, the court's required to do so in the least restrictive means necessary. So, Judge, in that effort, I have decided to present a couple of exhibits for the court to consider. I presented those exhibits to the court, and I want to go over those exhibits, Judge. I presented those to the defense. I have in court today as well. Exhibits, what's been marked as States Exhibits 1 and 2, Judge. Those are affidavits from Exhibit 1 is ISP Detective Jerry Holman. Yeah, Jerry Holman, the living lie detector, who, in my personal opinion, is clinically retarded. Problem is, he is clinically retarded with power. And I will stay. I'll stay with that opinion until proven otherwise. And Exhibit 2 is from Carroll County Prosecuting Officer Investigator Steve Mullin, who also can go fuck himself. They've both been involved in the case for several years. They have intimate knowledge of the details of the case. They both believe in their affidavit that releasing information would jeopardize the ongoing investigation. Hello, Mr. Jingles. Hello. Yeah, of course it would jeopardize the investigation because it would reveal their absolute incompetence, in my opinion. The next exhibit, Judge, it states Exhibit 3. That is a letter from Becky Patty. That is LG's guardians. She's in favor of keeping the records confident as well. And then, Judge, Exhibit 4 is an online petition that circuit not only the county, the state, and the nation. There's over 40,000 signatures on that petition. Also petitioning the court to keep the records confidential. I've never heard of that one, that petition. Never seen it. If anyone has the link to that one, please send it over. Never heard of it, never seen it. The state's moving to admit those 4 exhibits. States Exhibit 1 through 4 offered. Any objection from the defense? No, they didn't object. But in their defense, at that time, they had basically nothing to go on but the states, what they've been handed over initially. Jen the Couch Fairy, was there a petition to vote to keep it open? I don't think so, because nobody knew about the other petition. Not to my knowledge. I've never heard until this transcript surfaced. I've never heard of it. Until, I've never, States, let's see. Jody, I'll have you mark those at States Exhibits 1, 2, 3, and 4 as reflected by Mr. McClellan, please, and show those admitted without objection. It's Exhibit 1 through 4 admitted. Mr. McClellan, thank you, Judge. Judge, there's not a lot of precedent for a hearing like this. I searched high and low for case law, talked to several people. There's just not a lot of precedent. This is an unusual situation, an extraordinary circumstance, if you will. The state is confident in the evidence that's been presented in both the probable cause and the charging information. We're confident of that evidence and of the contents, but I'm concerned. I have two concerns: the continued investigation and then protecting the witnesses involved in that case. Judge, those are my two main concerns. Most of the witnesses were cops. And then alleged eyewitnesses who were at the bridge that day. And if you remember, and we will probably get to that at some point in time while me reading the trial transcripts, nobody got the question, is Rick Allen the person you saw that day? Because the state was afraid of the answer. Judge, those are my two main concerns. It's my job as the prosecutor, in part at least, to enforce the law in an effort to protect the community. It is the public interest for me to enforce that law to protect the community. The first concern talks about the integrity of investigation, and I think that falls under the public interest factor and consideration for the court. This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. Remember when McClellan got the question after the trial? What about the other suspects? And he was absolutely flabbergasted. What other suspect? What? No, never. Never. And here he is on the first hearing in front of Judge Gull, saying, our goal is to find anyone else who was involved in this heinous crime. Because up until trial, actual trial, in the opening statement that Rick Allen did all of this by himself, not a single person thought this was a one-person crime. Not one. That is the public interest, to find anybody else involved and get justice for Abby and Libby. We still get tips every day. Tips come in every day. We have good reason to believe that Richard Allen is not the only person involved in this. That there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. Oh, you found the petition, Andy. Great. So, it would be interesting to see the names on that petition. 40,000 names. Yeah. I wonder how many of them are related to other suspects or cops. Yeah. They always thought there were more. Nobody thought And I suspect that throughout the trial, McLeland, Holman, Mullen, everybody thought this was a multiple person. But in order to get a jury to convict Rick Allen, they had to go with a one-person crime. Andy, send it to via X. Send it via X. But yeah, everybody thought this was a multiple person crime. And I agree. This was a multiple person crime. Everything on the crime scene and everything surrounding how the girls disappeared kept being disappeared until the day after tells me multiple person crime. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? The public has an absolute right to the information. I don't deny that, Judge, but at what cost? This rule was designed for extraordinary circumstances where the court can limit that access. The state believes that this is one of those extraordinary circumstances. Keeping the record confidential serves the public interest. It puts the investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. The second part I'm concerned about, Judge, is the safety of witnesses and other people involved in the case. Yeah, because they believed other people was involved. And until they found the other people in this multiple person crime, of course witnesses were at risk. Because these are dangerous people who actually committed the crime. He continues, we have seen the extraordinary lengths the media has gone in order to get the next soundbite or the next clip for their broadcast. You provided them with it. So, but now it doesn't suit you. We are a society of people that has to know right now. Social media, Facebook, Instagram. We want all the information right now, immediately. The media has went to great bounds to interview anybody involved with the case. Mr. Allen's wife, Mr. Allen's old neighbors in Mexico, Indiana. They've staked out his house. Even by Rick Allen's own admissions, a letter to the court asking for a public defender, they forced his wife to move and abandon their home. They are talking about the media. We also know the prior judge, Judge Diener, recused himself by his own admissions to an email to the court's judicial staff. He had concerns for his safety, for his staff, due to the facts surrounding their arrest. So much to the point that he felt it was necessary to get out of the case, Judge. Yeah, but he never actually stated what it was. Why? He never did. And that is infuriating. Absolutely infuriating. When a judge recuses himself out of fear, he should be able to list each and every reason. And he didn't. Simply because I believe he's just a coward. He might have seen, this might have people look at me and every ruling I do. And I bet he knew that ex parte meeting, if he kept being on the case, would come back to haunt him. But now he's retired and cannot damage any other case. So fuck you, Judge Diener. Fuck you all the way to hell. And so the state believes these are real concerns for the witnesses and the people involved in this case. Look at the amount of security we have here today, Judge. We don't have a lot of security in Carroll County, but I can tell you, my tenure here, I've never seen the display of law enforcement that we have here today. They are there because you told them to be there, you fucktwat. This is a highly publicized case. We have had countless meetings over the couple months or past month about security, how to get Mr. Allen in here, all for the safety of everybody involved in this case. Why the fuck are those transcripts not a part of the appeals transcript? Every single word regarding Mr. Allen, his security, safety, how he's transported, every single word should be in the appellate transcript. And it is not. Why? It's infuriating. Blah, blah, blah. Should extend to the witnesses and should extend to the other people involved in this case. The court can imagine the media pressure, intimidation, and evidentiary issues that may arise if the name of the witnesses are released and those witnesses are subject to constant harassment and bombardment by the media. At this point, they thought that this was a group of people committing the crime and that people were out and large. So yeah, I can understand it. But with the facts at hand that we have now, fuck you, Mr. McClelland. The state also has concern that they may be interviewed on the 6 o'clock news and the testimony will be taken as such. That causes evidentiary issues. Some of the witnesses were juveniles at the time. They are now 19 and 20 in their first and second year of college. They need to be able to focus on what they're doing in school and not to be worried about the constant harassment from media. And I'll remind you, Judge, some of the people, some of the witnesses are still juveniles, and so there's concern there. Yeah, we know, Mr. McClelland, especially that person. When you remember, Rick Allen saw a group of 3 girls. McClelland told the court and everybody involved that a group of girls seeing bridge guy, group of 3, when they were actually a group of 4, but the 4th one was a bit younger. And he only did that to make it seem like it was the same group of girls. It was never the same group of girls. Never. You cunt. Again, Judge, the burden is on me. I have to show by clear and convincing evidence, and so the gauge starts at the presumption that the information should be released, and I have to convince you to move the ticker far enough to keep it confidential. And so, Judge, I looked up clear and convincing. We don't deal with it a lot. We deal with beyond a reasonable doubt. And so I looked up the jury instruction for clear and convincing. That is civil court, by the way. Jury instructions say the facts supporting the claims are highly probable. Look at what we hear today, Judge. The chaos, the amount of attention this has drawn, the concern for safety, defense counsel, the state, everybody has a concern for safety for themselves, for Mr. Allen, for everybody involved. Went to extraordinary lengths to protect everyone here today. We can't look at this case like any other case. This is an extraordinary case. It is by its nature. The state believes it's important and allowed under Rule 6 to keep the PC and the charging information confidential. All you had to do was to black out the names. But you wanted everything confidential because it would have shown early on the absolute... It's so bad. The affidavits and the charging documents, it's so bad. In my opinion, what they claim was enough for probable cause, it's not even close. It's not even close. The state believes it's important and allowed under Rule 6 to keep the PC, blah, blah, blah. Yeah. So the state respectfully would ask the court to continue to keep the PC and the charging information confidential. However, if the court deemed that those items should be released, the probable cause and the charging information, I would ask the court to consider redacting. He actually asked for it. I should have just kept reading. I would ask the court to consider redacting the witness's name to protect their identity and the people involved in the case. In an effort to do so, Judge, I have a redacted charging information and probable cause that I'd like to submit to the court for their consideration. It has names of the witnesses and the people involved in their case redacted. And if the court so inclined at this time, I'd like to at least admit to that to the court, not as an exhibit, but as for consideration for the court to consider a redacted version, as opposed to releasing the entire document. The court, any objection, gentlemen? Rossi says no, ma'am. Okay, thank you. I want to mark this as an exhibit. This will be my work product, so it's not available to anybody other than myself and my staff. Mr. McClelland. Thank you, Judge. So, Judge, I'm about done. I wanted to leave you with one last thing. As I said, I did a lot of case law research to find any support of my motion or anything that is not in support of my motion. I came across a case, Brown versus State, Indiana Supreme Court case. It's from 1969. It's old, but I wanted to read you a quote from the case because it's kind of hit home dealing with the circumstances that we have today. And the court says this, quote, the right of the news media to fairly and accurately report the news, the right of the defendant to a fair trial before an impartial tribunal, free of influence of generated prejudice and inflamed passion of the community, and the right of citizens to fully comprehend and analyze the administration of the court system are elements necessary to the attainment of justice. Elements necessarily to the attainment of justice. If any one of these rights fall, the rest will surely fall, and the term justice will become hollow and meaningless in our constitutional system. Okay. Yet again, the state's asking you to keep those things sealed. I appreciate the time here in court today, and I appreciate you allowing the state to have entered its exhibits and make an argument. Thank you, Judge. Thank you, Mr. McClelland. Mr. Rossi. Thank you, Nick. Judge, let me just start by saying that Mr. Allen, in this case, seeks transparency. It seems to me that, in the normal course of operation in our courtrooms around the state, that's what we get. That's the norm, and really there's no reason in this case to sway from that. I would point out first, if I could direct the court to the pleading that was filed on October 28th, 2022, the verified request to prohibit public access to a court record. This pleading, if you look at it, is deficient on its face. And I would direct the court specifically to the fact that Rule 6A specifically says, quote, a verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record. It requires a verification. And the verification in our business is that word is a term of art, as you know. IC 1145 codifies the very essence of what a verification is. And what you're going to find, and I would direct the court to Smith versus King. This case is a 1999 case involving an election dispute. Specifically, Headnote 3 of that case addresses what a verification is and what the minimum standard to meet that verification is. And it says, quote, when applied to pleadings, verified means supported by oath or affirming in writing. Pursuant to Trial Rule 11b, it's sufficient if the petitioner simply affirms the truth of the matter to be verified by affirmation or representation in substantially the following language. And it says, quote, we affirm under the penalties for perjury that the foregoing representations is or are true, end quote. The essential purpose of a verification is that the statement be made under penalty of perjury. And it cites Austin v. Sanders, 1986. This document contains no verification which references that has been signed under the pains and penalty of perjury. So I think it's facially deficient, and I would ask the court to consider that before we even get to the rest of this. And of course, I can offer up the case to the court, but I know you have the citation, so we should be good. Moving on, we get to the Access to Public Records Statute, this statute, open door law, all those kinds of phrases that get thrown around in our practice. And what I would say to you is that, I actually, when I took a look at this statute, I was actually surprised to find that the very first section, 514.3.1, the first chapter codifies public policy, and I think that's extremely rare in our practice when you actually see a statute that essentially codifies the public policy. And I'm not going to read the whole thing, Your Honor. You probably already looked at it. But the first sentence says, quote, "A fundamental philosophy of the American constitutional form of representative government is that government is the servant of the people and not their master." It sounds like something Thomas Jefferson wrote, frankly, but more importantly, you get the last sentence and it says, quote, "This chapter shall be liberally construed to implement this policy and place the burden of proof for the non-disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect." It says two important things. One, liberal construction, which means it pertains to many documents in our judicial system. And two, most importantly, it places the burden of proof on the state in this case, which Mr. McClellan has already acknowledged. And that burden of proof is, of course, the clear and convincing standard. So I think the point I'm trying to make here is that the legislature felt so strongly about the disclosure of public records that it actually codified the public policy. I just think that's really unique. And one of my counterparts that I practice, which would say, quote unquote, "That's pretty cool." It's just not the kind of law that we're used to seeing. So moving on, this Rule 5 is kind of the driving force here, actually, in this access to court records arena that we're in. And Rule 5 basically says that, exclusion upfront is, or the transparency upfront is where the court ought to be with this and only extraordinary circumstances should the court deviate from that. And that word, extraordinary, is the second word in Rule 6.2, by the way. And what you see, if you read through these rules, is that there are a lot of terms that are used to just really bolster and beef up that burden of proof. And I think they just speak to how important it is that we have transparency in this community, in this system, I should say. And that's no different in this case. So let's get to Rule 6. Mr. McClellan hit on a couple of the bullet points. One being that the public interest is substantially served by prohibiting access. Again, another strong word, substantially. Disclosure of the records will create a significant risk. Again, a significant risk of substantial harm to the prosecutor, other persons, or the public. Disclosure will work some prejudicial effect on the ongoing proceedings. So all strong words, again, consistent with the clear and convincing standard. Let's touch on the first one specifically. Will the public interest be substantially served by limiting access? And Mr. Allen's position is no, it will not. It's exactly the opposite. This is a case where the crime occurred over 5 years ago. It's taken almost 6 years for an arrest to be made. Time and public resources have been exhausted over that scope of time. Those are almost impossible to quantify. And any secrecy involved in this investigation, in my opinion, and Mr. Allen's opinion, has done nothing but increase the hype and the public interest. I mean, it's the idea that the public has known very little is what has caused, all this attention to occur. And so, by continuing that pattern or allowing the state to maintain this confidentiality, I think we're just the problem. Enhancing the problem. My suggestion is that the opposite would happen if you unseal the records, and that is to say that the public can see the truth regarding the facts. That supports the allegation. In this case, they can see where the expenditure of their tax dollars has gone. And Mr. McClellan talks about the second prong here, and that the release of the records would create a significant risk of substantial harm to the prosecutor, other persons, or the public. At this point, I don't want to sound flippant, but what's the risk? I mean, we all just walked in here today, with security and the right safeguards in place, and we're fine. There are a few human rights referenced in the affidavit, and I do understand that they may play a little bit larger role in the court's opinion today, just trying to protect those individuals. And, frankly, Mr. Allen, the defense doesn't have any problem with redacting some names of witnesses and things of that nature that might serve a purpose. But, I haven't heard, or nor have I seen, in any of these exhibits that were introduced by the state, any actual references or appreciable threats that have occurred. Thank you, Lark. Perpetuating. Thank you. I like my audience. I like my audience. You do good. You do good. In appreciable threats that have occurred. In other words, we didn't John Doe or Jane Doe come in here today and tell you that they have received a phone call from an anonymous person last week with a threat on their life. I haven't heard an officer say that he or she their lives have been threatened. I think a lot of this is just driven by the social media aspect of this. You can get on Facebook any day of the week and find somebody threatening somebody. Not that I don't take those things seriously, but it's like fast food. Most of that doesn't have a lot of quality to it. It's just quantity. And I haven't heard any evidence today, other than some argument about the law, which actually supports the idea that there are any appreciable threats on anybody involved in this case. And so, any suggestion at this point regarding the second prong that there will be some significant harm to the public or people involved, I think it's just conjecture and speculation. Moving on, there's a practical problem here too. And the practical problem is if the court orders these records to remain confidential, we're going to be forced to walk into this courtroom and delicately dance around all the factual scenarios in this case because the public's going to be sitting behind us. And that doesn't seem to make any sense. It seems to make things more difficult. Yeah, I think that's the actual goal here. You're going to have people reading between the lines. All this stuff's going to go down in print, and then you're going to have all these, the public trying to decipher what we did and didn't say, and what we're inferring, and it makes our job way more difficult. I would argue that it's going to make Mr. McLeland's job more difficult. Yeah, I know. Classic overthinker. Rick was threatened daily. And they didn't care one bit about that. We got a bond motion pending. How do we talk about law and facts in the suppression hearing? How do we talk about law and facts in the hearing of change of venue? All those things which are pretty customary in cases like this. The public will be sitting right here the whole time, and so it just doesn't make any sense practically either. And I'll just finish with this. The burden again. We talked about the clear and convincing evidence. I haven't gone back and counted. I didn't, do any internet searches before I came in here today. But over the last 5 years, I had some very integrated memories of state police press conferences in this community. Yeah. I don't know if there were 2 or 4 or 6 or 8 or 10. I frankly don't know. It seemed like a lot. And, in my mind, for the state to come and for the state to be a part of that process of having public press conferences, releasing composites, things of that nature, and asking the public for help, and then turn around today and suggest to the public, we don't really want you to see what's here. It's kind of like talking out of both sides of your mouth. I mean, that's the way I view it, and I think that's the way Mr. Allen views it. And, we think that the standard is extremely high here, clear and convincing evidence. Nick gave me a little crash course on what the Black Law Dictionary says. What I know about clear and convincing evidence is, for those of us that practice in civil court from time to time, it's the standard that we employ when we are trying to terminate somebody's parental rights, which I think is pretty darn high. And to say that the state has met that burden in this case, I think is just not accurate. None of these documents that you've seen has any information in them which suggest anything with detail that somebody's in harm's way or that some other suspect is, out there and needs to be apprehended. It's just conjecture, and we would ask that you unseal the records, if you will, for the lack of better phrase, and let's move on with this. Thank you. And a response, Mr. McLeland? Mr. McLeland, no, Your Honor. The court says, well, gentlemen, I really appreciate your excellent oral advocacy. I will take the petition under advisement to review the exhibits that have been submitted, the case law that has been argued by counsel, and issue a written ruling in due haste. I know that this case has generated a lot of public interest, and I know that the attorneys and Mr. Allen deserve this court's attention as quickly as possible. I know with the holidays coming up, that will not interfere with my ability to review my notes and the exhibits and issue a written ruling. Mr. Rossi, you and Mr. Baldwin did file a motion or a petition to let to bail. Can we set that for hearing while we are all here today? Mr. Rossi, yes, ma'am. The court, so that we can get that matter resolved. Are you looking at this year as well, or Mr. Rossi? I'm thinking January. Is that the court? You're thinking January, Mr. Rossi? Yeah. Mr. McLeland, yeah, that's fine, Judge. I'm out the first week in December, and then we have a jury trial starting here December 12th. So December is kind of the court. Okay. Mr. McLeland, shot from the state's perspective, Judge. So I'd be looking at January as well. The court? Okay. Mr. Rossi, I think my biggest concern is just frankly giving Mr. McLeland's office some time for him to gather some of the basic discovery and us being able to have a little time to sort through it. The court, I was going to ask you about that. Mr. Rossi, yeah. The court, I know that the prosecutors indicated it's pretty much an open file discovery policy here in Carroll County. Oh, no, it's not. Oh, no, it's not. It's not. Mr. McLeland answers, it is, Judge. Yes. You fucking liar, Mr. McLeland. You did everything to hide things from the defense. You tried to hide the other suspects. You tried to hide other suspects that had confessed. You tried to hide everything about the Odinist theory. You tried to hide everything that pointed to other people than Rick Allen. So this, you lying sack of lies. Miss McLeland, it is, Judge, yes. The court, you received what? Anything? Mr. Rossi, well, just a PC affidavit. The court, okay, so you don't have any of the formal discovery from the state of Indiana. Mr. Rossi, yeah, I don't know what the volume's going to be like, so I don't want to get ahead of ourselves on the scheduling issue. I wouldn't even have a problem in the early February even, if that's reasonable, or am I, Attorney Andrew Baldwin? No. Mr. Rossi, late January, early February. Mr. Baldwin says, I would like some time to the court. Are there any particular days of the week that work better? I'm looking at the first week in February then, if that's what you all are talking about. This is my calendar for the next 2 months. So just so you know, Indiana also have the equivalent. It is basically a Rule 14. The moment Rick Allen was charged, it's an automatic discovery. Hand it the fuck over. There are obligations automatically once Rick Allen gets charged. Every affidavit, every probable cause affidavit, every search warrant, everything. Boom, here it is. Should have been handed over at this hearing, even before this hearing, to attorneys Rossi and Baldwin. And to my understanding, not all was, I mean, it's insanity, the amount of information they still have. And in my opinion, at this point in time, they already knew the first 70 days was gone. They knew. So this is just theater from the prosecution. Mr. Baldwin, Judge, I will be in a murder trial down in southern Indiana first week of February, so that would not work for me. The court, so that won't work for you. Okay, how about the second week? I'm in a murder trial every week, just so you know. Mr. Baldwin, yeah, let's see here. The court, so the second week in February. Mr. Rossi, I'm more open than it sounds like than the court. Second week of February is fine with me. Mr. Baldwin, not knowing how long that trial is going to last, if we're going to do the second week, I prefer like the 10th. It should be completed by then. I hate to continue it. The court, okay, I was looking, so you're looking at the first full week, the 10th. Mr. Rossi, Friday, you're saying the 10th. Mr. Baldwin, right. The court, I don't want to jam you up. I mean, if that's not a good day, we can go to the week beginning February 14th. Mr. Baldwin, I'd actually prefer that because I'd like to come out of that trial and have time to prepare for the court. Okay, Mr. Baldwin, the hearing. I appreciate it. Of course, I also have another murder trial scheduled that week, but I don't think that's going to go. So what about February 17th? Will it take all day? Is that fair? Half a day? Mr. Rossi, I think we should set the day aside. The day? The court? Mr. Rossi, just to be, until we get off and running here and we have a better idea of kind of how quick the lawyers work and that type of stuff. The court, okay. I'm okay with the 17th. Nick? Mr. McClellan, that's fine. Mr. Baldwin, yes. The court, all right. February 17th, can we start at like 10? That way my staff and I don't have to get up that early. My intent is to have that as many hearings here in Carroll Circuit as possible. I have no idea what the calendar looks like for the sitting judge. Folks, this is before. Now, at this point in time, Mr. Allen is in solitary in prison. And Mr. Rossi, Mr. Baldwin, still, at this point in time, they still don't know how limited they would be in meeting with Rick. They, at this point in time, didn't know that the guards would film them in their meetings with Rick. They didn't know his guards, Rick's guards, would be people with Odinist patches. They didn't know at this time, and probably had no idea what they were in for. For them, this was just a normal trial. Everything should get smooth. Everything should be handed over with no issues. They had no idea at this point in time what was going to happen later. No idea. She continues, I have no idea what the calendar looks like for the sitting judge. Mr. Rossi, sure. Mr. McClelland, we don't have anything on that date as of now, Judge. The court, okay, as of now. Mr. McClelland, I have the court calendar. Now that obviously is subject to change, but right now there's nothing set for that day. The court, okay, so we could set it February 17th, 2023 at 10 a.m. And I'll make sure that Mr. Allen joins us. I'll get the transport order. All right. I know that we have an Omni hearing in January. There's already been a trial setting, and it was my understanding when I spoke with the judge before, after his recusal, that the trial setting is a first setting. Mr. McClellan, that's correct, Judge. Jadzia, they know there was nothing normal about this trial. Yeah. At this point in time, Rick Allen had just been transferred to a prison cell where the guards, the inmates, the prison psychologist, the investigators, and the judge all cooperated, knowingly or unknowingly, in breaking Rick down. And he broke. The court which, Mr. McClellan, when the prior, sorry to interrupt the court, when the prior judge said it, he did said it as at the first setting in March. The court, okay. Mr. Rossi, I'd say we just let it sit for now till the court sit. Mr. Rossi, yeah, I mean, we're not setting aside that week yet, right? We just have the date on the calendar. Mr. McClellan, so do we need to change the omnibus date to the let bond date hearing date? The court, I'm happy to do that if you'd like. Would that be easier for you, Mr. McClellan? I think that makes sense, but Mr. Rossi, I think it's a good idea. The court, okay, so cancel January 13th, and we'll just do February 17th as a bond hearing and an omnibus hearing. And that's satisfactory to counsel, Mr. Rossi? Mr. Rossi, yes, ma'am. The court, okay, is there anything else that we need to do on the record, Mr. McClellan? Mr. McClellan, I don't know. I don't believe so, Judge. No. Mr. Rossi, nope. The court, Mr. Rossi? Mr. Rossi, no. The court, all right. Thank you, gentlemen. Mr. Rossi, thank you. The court, I appreciate your advocacy. Mr. McClellan, thank you, Judge. The court, ladies and gentlemen, as I indicated, if you would all remain seated until the parties and Mr. Allen had been removed from the courtroom. And this concludes the proceedings held on November 22nd, 2022, Indiana, this cause.